You're very welcome to the Child Safeguarding Practice Review Panel webinar. Today we are going to look at what is good practice for notifying and reviewing serious child safeguarding incidents. So we're going to cover a number of different topics, including SINs, of course, and also talk a little bit about rapid reviews and LCSPRs. We've got a number of speakers today, and so I'll hand over to them shortly. But if you haven't heard the announcements, just please check in the MS Teams chat here, where you'll see the link to the forum. That's where you're going to see the slides today, and the opportunity again to add questions and comments, which we will pick up shortly in a Q&A session that will start at roughly 4:30. I'm delighted once again to hand over to Sir David, who's going to kick us off today. Sir David.
Steve, thank you very much, and good afternoon, everybody. It's fantastic to see so many of you joining this webinar today. For colleagues who haven't been to one of our recent webinars, just to let you know that we're running monthly webinars now at the panel to discuss issues of interest to everyone and to do everything we can to support good practice in safeguarding. I'm delighted today that I'm joined by two of my panel colleagues, Sally Shearer and Ian Critchley. They'll both be speaking later on in the seminar, and I'm sure they'll introduce themselves to you then. Just to introduce you, if you need to be introduced to the Child Safeguarding Practice Review Panel, it's an independent body that works to identify, commission and oversee reviews of serious child safeguarding incidents. So the panel meets every fortnight, and at all of our meetings we review rapid reviews and local child safeguarding practice reviews that have been submitted to us in that intervening period. In a normal meeting, we'll probably review between 15 and 20 cases. So the panel has a very privileged position in being able to keep an overview of these very serious incidents involving children and young people, but also we are very well positioned to be able to identify and share learning. And we're working very much on a mission at the moment to increase our analytical capacity, but also to create more accessible resources to practitioners. And you'll be seeing a new online resource hub launched by the panel early next year. On this slide, you'll see the current members of the panel. It's very much a multidisciplinary panel with people with a range of different professional backgrounds that can ensure that we have really rich discussions within the panel. People from social work, health, policing, education, legal and other backgrounds, all reflecting the range of multi-agency skills that we need in safeguarding. Now, if we move on again, a key issue and responsibility of the panel is to ensure that we're supporting safeguarding partners in terms of the notification of serious incidents where a child has died or suffered serious harm as a result of abuse or neglect, and then the rapid reviews and local child safeguarding practice reviews that may follow on in course from those very serious incidents. And we publish guidance to support you in understanding when to make those notifications to the panel, but also to ensure that we're supporting you to think about the approach and structure that you need to apply in terms of rapid reviews and local child safeguarding practice reviews. We keep our guidance to you under review. The most recent version was published just in June this year, and so colleagues who were closely involved in developing that guidance are on this call to talk about some of the key changes that we've made to that guidance And the guidance very much complements the statutory framework set out in working together to safeguard children, and is intended to be a really practical resource to help you meet your statutory responsibilities as effectively as possible. The guidance is relevant to everybody working in safeguarding who may be responsible for making serious incident notifications, or for undertaking rapid reviews, or for conducting local child safeguarding practice reviews. We view this guidance very much as a live document. We will keep updating it as it needs to be updated, and the feedback from this session, and indeed from yourselves on an ongoing basis, will help us to keep the guidance as current as possible. Before I hand over to my colleagues, I just wanted to say a few words, if we go to the next slide, on serious incident notifications and why they're so important. It's vital, colleagues, that we learn from these most serious incidents, but the best way in which we can learn is being aware as soon as possible after these incidents have happened. And that's why it's really vital that serious incident notifications are made as soon as possible. They need to be notified within 5 working days of you becoming aware of the incident. And we understand that at the point of notification, the SIN may contain limited information because it's at such an early stage. What's really important, though, is that that notification is made quickly, because once the notification is made, it then sort of kicks off the next stage in the process, which will be the development of a rapid review. And the whole point of the rapid review is to identify, to ensure that children are safeguarded, but also to identify any immediate learning. So making sure that process is started and we're identifying learning really quickly is vitally important. We also keep a very careful eye on SIN data across the piece, and we are concerned that notifications have fallen for the 2nd consecutive year. So they have currently reached their lowest levels since the statutory duty to notify the panel was introduced. So this is notifications both relating to child deaths and serious harm. So at the moment, they're at their lowest level of notification since 2019. And that has to raise the question about whether all eligible incidents are being appropriately notified. And we are noticing discrepancies between the SIN dataset and other datasets, such as child death reviews and exploitation cases, which may suggest that there's some potential underreporting or inconsistencies in local thresholds and practices for notification, which is another reason why this webinar is really important today, because achieving a common understanding of when to notify a serious incident is really important. As you'll see from this slide, there is also regional notification in regional variation in notification. And that may reflect genuine differences in incident rates. It can be influenced by a range of other factors, such as deprivation levels, for example. But it is interesting to see these differences in notification and to make sure that we're asking the right questions about why those differences in notification levels exist, and to ensure that notifications are being made in every case where that's the right thing to do. It's also, I think, really important, colleagues, when we're thinking about serious incident notifications and rapid reviews in LCSPRs, to also have an eye on the forthcoming development of the Child Protection Authority. So we know that there is lots of policy development around the CPA at the moment, and in the future, when we have a CPA, that will be keeping a real overview of safeguarding nationally, serious incident notifications and the reviews that follow them. So there is a really bright spotlight being shone on these notifications at the moment and on ensuring that we're maximizing learning from the reviews that follow them. So really important that we work together to get this right and that all serious incident notifications are made as soon as possible. And I'm going to pass to my colleague, Sally Shearer, who will talk more about why we notify SINs. Over to you, Sally.
Thank you, David. Just to introduce myself, my name is Sally Shearer. I've been on the panel for 3 years. I'm a registered nurse by background, and together with Ian Critchley, we led the revision of the panel guidance. And as David's already articulated, the panel guidance is rooted in Working Together 2023, and I'll assume everybody on the call knows the criteria for a notification, which is where a child dies or experiences serious harm and abuse or neglect is known or suspected. A local authority on behalf of the Safeguarding Partnership should notify the panel within 5 working days. And as David articulated, notifications are that first crucial step in learning from serious safeguarding incidents, and they enable reviews to follow on to explore what happened, why, and how risk of future harm can be reduced or prevented. The aim of a review isn't to assign blame, but to understand the systemic issues and improve practice. And notifications are absolutely that gateway to the learning, and without a SIN, a case cannot be reviewed, or the opportunity to identify improvements could be lost both locally and nationally if that doesn't happen. And we know from our conversations with you that many safeguarding partnerships have very early processes in place internally to agree which incidents actually get notified to the panel. And all of these measures contribute to the safeguarding system being dynamic, very responsive to current trends, and a self-improving safeguarding system. So the panel guidance outlines that notifications must include key details about the incident itself and the child or children that have been involved, together with information about their families and any prior contact with services. And within that notification, there should be some assurance that actions have already been taken to make sure that child or any other children linked to the incident are safe. They should clearly distinguish between what is known and what is suspected, and within that 5-day time frame, sometimes you may not have all of the information. So it should be clear what else you are waiting for information on. And I think it's really essential that senior decision makers, perhaps your delegated safeguarding partner, has oversight of notifications and rapid reviews and LCSPRs when Ian comes on to talk about those. But that's because certainly your serious incident notifications, they are seen by ministers. So they are, seen by some really senior people within government, and therefore to reflect your competence and your professionalism within a safeguarding partnership, it's good to have that sign off from some senior leaders. And then coming on to shared responsibility for learning. Oh, sorry. Yeah, thank you. Learning from serious safeguarding incidents is absolutely a shared responsibility. And we know that a lot of the legwork, if you like, is undertaken within safeguarding partnerships because you are responsible for undertaking those local reviews, and they involve an awful lot of work. But then nationally, we are responsible for having oversight of that learning and sharing it across the system. And that is through our webinars and our newsletters. That's something that we're really looking to strengthen. what we have tried to do within the guidance is to support professional judgment, because what we really recognise is when you're thinking about that threshold, no two cases are the same. Some of them are very similar, but all of them have their own unique context and background, and therefore those notifications and reviews need to consider that specific content around the incident. And it's really good to come around the table as a multi-agency partnership to have those discussions. So I think finally, just to say that it's really critical that we get accurate and complete data, not only to provide assurance on your immediate safeguarding responses, but also for national reporting and trend analysis, which does influence policy development. And so it's really important that you include all those relevant characteristics and be really specific about linked individuals to help surface those systemic issues and inform future improvements. And we do really use that data to identify patterns and gaps that may not be visible at a local level, but certainly from a national level, there's some very strong messages that we get from the reviews that come from across England. This slide just runs through some of the key changes that we made when we revised the guidance. And of course, a key driver for the revision was the changes that had been made as part of Working Together 2023. But also learning from recent cases, feedback from yourselves, and also the analysis that's contained within our annual reviews. So in terms of Working Together 23, as you know, that really emphasised the equal and shared responsibility that the three safeguarding partners, police, local authority and health, have, and also introduced the role of a delegated safeguarding partner. And then also thinking about that real strong relationship and how education and early year settings can really be drawn into the partnership discussions, because we know those education and early years have some really rich information for school-age children and those who are attending nursery. What we tried to do was to clarify areas of ambiguity, things that we know have caused uncertainty for safeguarding partners. We know that from the emails that we receive from you, particularly around the definition and threshold of serious harm. And we aimed to give case examples, questions, practice boxes, so that you can work towards a more consistent, transparent and reflective decision making to reduce variation in local practice and ensure that decisions are better informed and aligned with national expectations. So a real greater, what we're calling for is a greater focus on analysis. Good reviews aren't just about a story of what happened, it's why they happened. And we've tried to provide additional guidance to help with that. Obviously, just before we published the panel guidance, we also published the panel's thematic on race. It's silent, and we know that many of you reference that today in the rapid reviews that we receive, race, ethnicity and culture. And that's really important, and what that really showed and made evident from the analysis was that rapid reviews and LCSPRs didn't always consider the impact of race, culture and ethnicity on a child's lived experience, and it could also have influenced the response of the practitioners who are working with that family. And so through the practice questions and the case examples, we've tried to give you additional guidance to think how you can strengthen those particular aspects of your reviews. We've tried to give expanded guidance on specific circumstances. Again, these are issues that you raise with us. So we were thinking about circumstances involving young people who may have just gone over the age of 18, but who their experience of abuse may have happened during their childhood. Also thinking about serious youth violence. And we've tried to provide a lot more guidance and examples there also to make things clear. And as I said, it's really hard to give hard and fast rules and criteria and tick boxes because every case is different. And so we approached it in this way. And then the other thing that we get a lot of questions about is when LCSPRs in particular are running at the same time as other processes, for example, domestic homicide reviews, child death overview, panel reviews, and particularly around criminal processes. So we've tried to give additional guidance on that. So I think that's all I wanted to say for now. So I'll hand over to Ian to talk about rapid reviews and LCSPRs.
Thanks very much, Sally, and good afternoon, everyone. My name is Ian Critchley. I'm a retired Deputy Chief Constable and a former National Child Protection Lead. I currently work with the College of Policing, and I have been on the panel for 2 years. It's a real privilege to speak to you, and I've worked with Sally and the panel on the guidance. And thank you for the feedback, because this was done with partnerships, and hopefully, again, this session is adding value to all our understanding. I'm going to just talk through, just in a short space of time, because we want to leave plenty of time for the rest of the webinar for questions, just some key areas that we as a panel, from reading thousands of cases, believe are key attributes that make up good and effective rapid reviews. They're not exclusive. I recognise there's a whole host of experience on here as well, but these are some common features of strong reviews, starting with a real clear rationale for notification. We find that the reviews are strongest when they begin with a real clear, thoughtful explanation of why the case was notified. It demonstrates that the partnership has been engaged meaningfully with the statutory guidance and made deliberately informed decision. It helps answer those questions around abuse and neglect, but also around death and serious harm, and sets the tone, we find, for a really purposeful review from the outset. In terms of timeliness and structured process, we look for reviews to be completed within the expected time frame of 15 working days from notification to ensure that learning is captured. And I suppose that's the purpose, and by very nature of the title of rapid reviews, important that they're not done so lightly, that we don't withdraw any learning from them, but of course recognising some of our learning from the past of serious case reviews that may have taken a significant amount of time, an ability to get momentum, prevent drift, and increase the likelihood that findings can influence practice and decision making at the earliest opportunity. Focus lines of inquiry, again, finding that we find that effective reviews begin by identifying a small number of well-defined key lines of inquiry. There's often a temptation to seek to delve into every single element of that. Often that can be done working very closely with the individual agencies, but as a partnership, really focusing on those key lines of inquiry. This allows critical questions, shapes the direction of the review, and ensures it remains focused on the most relevant safeguarding issues for that particular instance. It also helps, and Sally's outlined this, to really focus in on analysis. So rather than a list of information of a long chronology, it helps really focus in on the analysis that is pertinent to those key lines of inquiry, provide clearer findings, and therefore actionable learning. We think it also helps ensure the review adds value by addressing what matters most importantly to practitioners and decision makers. And then finally, in relation to rapid reviews, in relation to multi-agency collaboration, you get a real sense of strong reviews that reflect genuine collaboration across agencies. This goes beyond just collecting information. It involves shared reflection, challenges, and learning. And again, we've seen that, and Sally's described the sign-off, but also within that sign-off, real detailed analysis by the DSPs. And when partners contribute meaningfully, the review benefits from a real rich understanding of the case and context in which decisions can be made. And with a well-constructed rapid review, this can often negate the need to progress towards an LCSPR. The most impactful reviews result in clear, practical recommendations that can be implemented locally and inform wider system improvement, but they also connect to other reviews that have already taken place and take cognizance actually of whether previous actions in relation to the same issues have had an impact. And we'll just do a couple of minutes on our key learning from our reading of effective LCSPRs. So, as we know, these are a key mechanism for understanding really complex safeguarding cases and driving meaningful change to be completed within 6 months of making the decision that an LCSPR will take place. And let me just pull out a couple of really important areas. So in-depth analysis, strong reviews go much beyond surface level descriptions. They explore the underlying reasons behind what's happened, identifying root causes, systemic issues and patterns in professional practice. And it's this depth of analysis that helps uncover learning that can lead to lasting improvements. And effective reviews are supported, and this we find often sets the scene with a really clear but concise chronology that helps identify key events and decision making moments, and really does set the tone for then what follows. In relation to actionable learning points, well, we've already covered that to some degree in relation to rapid reviews, but effective reviews translate findings into clear practical learning, not just observations, but specific relevant points that guide safeguarding decisions, improve frontline practice and inform strategic plannings. We find that strong reviews link findings to local and national reviews. We've seen that very recently in relation to connections with recent reviews, as Sally's identified in relation to its silent review, but also the child sexual abuse in the family, home and environment. This really does help embed learning across the system, and that leadership sign-off that we've mentioned plays a critical role in ensuring it's not only acknowledged but acted upon. It reinforces accountability, supports consistent implementation and drives that cultural change. In relation to engagement with families and practitioners, well, we know that meaningful involvement of those directly affected, including families, frontline practitioners, and where possible, the child's voice really does bring invaluable insight into the review. And this engagement ensures that learning is grounded in lived experience and reflects the very human impact of safeguarding decisions. For me, it really does take it away from this is not just a process, there is a real human impact, a child that's been seriously harmed or killed in relation to this, and really does ground us in terms of the learning that we seek to take. It supports more inclusive and responsive practice. That allows us to drive systemic improvements. The LCSPRs are most powerful when they lead to change beyond the immediate case, rather than focusing solely on compliance. Strong reviews inspire improvements in policy, practice and culture across the safeguarding system and help to prevent future harm. And of course, help us determine whether national reviews will take place, such as that took place in relation to Arthur and Starr. And then finally, we've already touched on this, but important that effective LCSPRs consider race, ethnicity, other factors that shape lived experience and safeguarding outcomes. This focus promotes inclusive and reflective practice, ensures that reviews are sensitive to the diverse context in which children and families live, and really does embed equity into reviews. So I'll hand back to Steve, but LCSPRs are most impactful when they go beyond surface level findings to deliver in-depth analysis of systemic issues. They identify root causes, draw on focus lines of inquiry and connect learning to wider local and national context. They include the child's voice, engage families and practitioners, and consider diversity and equity throughout. And with clear actionable recommendations by leadership, help really drive meaningful system-wide improvements in safeguarding practice. Thanks for your time, and Steve, I'm going to come back to you.
Great, thank you, Ian, and thank you, Sally. Thank you, David. So lots of information. There's quite a few questions we can cover. Some of those that you've already covered in kind of subsequent elements in the presentation. But I also want to invite people that they can raise their hand here in MS Teams and come off mute and ask a verbal question. But I don't know whether Sally and David, you've been monitoring the questions coming in, but there's a number of different topics that we can come back to and reiterate. Some quite specific, like question 3 about out of area notifications. So it'd be helpful to have clarification, it says, as to which local authority should make the notification in relation to a child who is placed out of area. Should this be the placing local authority or the local authority where the incident of harm or death occurred? Discussions around this have caused some delay in making notifications. Do you want to just clear that up straight away, David? Is that there's a direct answer to that? Yeah.
So the notification should be made by the local authority where the death occurred.
Fine. Okay. So geographically where the death occurred. that's the local authority. Great. There is also some reflections from colleagues on the reasons behind reductions in SINs and rapid reviews. This number 6 and number 4 cover this. So our partnership recently acknowledged a reduction in SINs and RRs over the course of the year. We had an honest senior strategic partner discussion about whether we had missed anyone or anything, if our number reflected the true picture. We decided the latter. I suppose the question arises about if the reduction might be part due to improvements. We will never really know. Ultimately, a reduction in the number of SINs, is good news. Although you're expecting it to be kind of, a relatively stable number. Comment on that?
I think, Steve, what's really important there is that you've had the discussion locally, and you've thought about that together, and you've explored the issues together. I think that's what's vital, and that explanation may be absolutely correct for your local area and your local safeguarding partnership. What is vital, though, is that, as I said before, that all serious incidents are notified when they need to be notified to us. And there was an interesting question in one of the questions asked about, it would be useful to have a contact line. And just to emphasize to everybody that you can always contact the panel if you're unsure about whether a notification should be made. Indeed, really quite often I speak to safeguarding partnerships, or my colleagues speak to safeguarding partnerships, often in quite complex cases where there is, questions being asked about whether a serious incident notification should be made, when it should be made, maybe because the facts aren't quite clear yet, maybe there's more than one child involved, and we're always very happy to advise in those cases, but also you can expect that the advice will be, tell us what you know as soon as you can, so that we sort of get the information in the system, and so that we sort of start the process of learning from what's happened. But we will always be reasonable, and we'll always do whatever we can to help. We understand that often these cases are very complex, and there's lots of different issues to consider, and we can help with that.
Just a little bit more on that, David. So if a partnership contacts the panel, who and how do they get a response? Do you put them in touch with somebody, or is there a most appropriate person?
Exactly. So there is a panel secretariat email address. I'm sure we can put that in the chat, and that message will be picked up, and you'll be put in contact with the right person who can help you to move forward. But really important to know that advice and support is there. I was also really interested as well, Steve, to see the comments in the chat about safeguarding partnerships where there are disagreements about whether a SIN should be made. Maybe different partners are disagreeing whether the threshold has been met. And I was really interested to see the example, I think it was from the Wirral, that you've developed a local process to be able to respond to those issues locally, and you've found a way through that. Again, what's important is that the notifications are being made when they need to be made.
Yeah. Good. Okay. Brief pause for Ian or Sally to come in on that if there's anything to add.
Yes, I would just echo what David said. We do know that safeguarding partnerships very often have their own local procedures and escalation processes for when there's disagreement, either with SINs or around at the end of a rapid review, whether to go to an LCSPR or not. So I think that's really useful. It is a partnership decision, but very often within the documentation there will be a comment that not all partners were in agreement, and I think that's quite useful to have in a document, because if the panel also have some concerns about the decision and then we move into a meeting with the partnership, it's good to know what the conversations have been in the background around that.
Good, thank you.
Yeah, my point, Steve, we're just going to be around. I think I see some things around timeliness and the realistic of time scales around that. And we did have a lot of debate and consultation with partnerships around that. And we feel, and again, I think that again, where do you put the line in relation to the importance of needing to ensure that the process is done rapidly? And I said finding that equilibrium between doing it rapidly but doing it meaningfully as well. And all we ask is therefore that partners seek to achieve that within the timescales, but clearly we stay notified in relation to that to be able to track it through. And we've now enhanced our own processes to engage back with partners, to have that dialogue where timescales may push on. And similar with LCSPRs, there are many reasons and many complexities in relation to that. One particular area that keeps coming up in relation to LCSPRs is ongoing police investigations or judicial processes. And again, we are really happy to have dialogue with partners. We often find that there is sometimes especially locally, you cannot progress with this, so it will interfere with justice. Clearly, none of us want to interfere with any judicial processes, but we've found with good partnership dialogue that parameters can be put on that allow often a review to be largely undertaken or completed, and then there becomes a decision around publication where proceedings may be on, rather than a hard and fast rule that reviews have to stop and can only start 2, 3, 4 years down the line, and therefore we miss the learning and immediately impacting on practice along the way.
Great, thank you very much. So I'm going to come to another couple of topics. One is looking externally about the rapid reviews, and one a little bit more internal about serious harm criteria. But first, in fact, Amina has been busy responding to some of these, so please check into the forum and see if there's a comment against the question you've asked. The first one is number 7. What are the types of policy development that you, the panel, expect from sharing the rapid review data? And I guess that's on the back of number 5, which is, can you explain more about who is briefed on the SINs and RRs, perhaps within the DFE and beyond, and who does what with those briefings, and what happens to that wider group of people that you said were receiving the SINs?
Well, Sally, do you want to take that one?
Yes, I'll make a start. So in terms, it is, to be clear, it is just the SINs that are shared in the DFE. They don't have access to the rapid reviews, and obviously only LCSPRs if they're published publicly. In terms of the policy development, some of our time on a Tuesday when we meet is spent on business, and we are very often networking with other departments. For example, we are feeding into the revision of the next iteration of Working Together. We've also worked with the team looking at the single unique identifier. So very often we're using themes that we've seen from our own data from SINs and rapid reviews in those conversations. Where there's a national recommendation, obviously they do influence policy, and a really good example of that is with the Arthur and Starr review, child protection in England, where the recommendation to form multi-agency child protection teams is now within the Child Schools and Wellbeing Bill. I think also very often we pick up themes and we write to other stakeholders, not necessarily government departments. It might be Network Rail, it may be the judiciary, just to bring things to their attention. Particularly if it's a community safety issue, we might pick that up with our colleagues in NHS England, around Public Health England, when health promotion advice is going out to families. So it's very much dependent upon what information is coming into the panel, but we don't just read it, we do something with it, I think was the point that we wanted to make.
Yeah, thank you. Thank you for that clarification. I'm going to move us on to the questions which are covered by 8, 10 and 13. Again, Amina's been responding to some of these, but Let me start with 8. So I'm going to play devil's advocate, the author suggests, and say that serious harm criteria for sin is widely interpreted, and in the busiest and most stressful multi-agency system I can ever recall, it's incumbent on somebody spotting the serious harm and bringing it to the attention of the partnership business manager. If that doesn't happen, it's unlikely the sin gets made. And 13 is in my area, there is sometimes conflict between the practitioners and the LSCP about whether the threshold for a sin has been met, particularly where practitioners feel that children's social care threshold has contributed to the harm. That's quite a difficult line to walk, isn't it?
But I would also though, Steve, just come back to some of the things I was saying at the beginning, that if we're all, and I know we are, working to protect children and improve safeguarding arrangements over time, then we're all accountable for ensuring that these most serious incidents are notified. And so we need to make sure we have the systems and processes in place to make sure that those notifications happen, and that when they happen, that they're good quality, so that we can share the learning about what's happened and work out, what we can do as a result. So I think this is about joint accountability and everyone taking responsibility for making sure that these notifications are made when they need to be made.
Okay, and so if in doubt, submit a sin, and
or talk to us.
Yeah,
or talk to us. Yeah.
Ian?
Yeah, thanks. I think it's a really valid point, and none of us would we would all recognise the huge demand here, but also everybody on here will recognise the importance of the system in which we're working in and seek to learn from some of the most appalling incidents and abuse against children. I think the most important bit is, and again, hopefully this webinar helps people just to take a step back and say, have we got processes at a local level that is allowing us to have discussions as to whether children have been killed, harmed, and actually whether the criteria for a notification is taking place? How robust are those processes, and what's the decision making in relation to that? We've seen, and it came out of Casey, that again, an example that's just being reviewed further now is in relation to group-based exploitation, often title grooming gangs, that notifications in relation to the most appalling group-based rapes of children, we see very little numbers of referrals of notifications. Something that's gone on for many years, and that's being worked through. Similar, we see some disparity in CDOP data where there is identification within the death of children that abuse and neglect have occurred, yet there is disparity in terms of numbers then of referrals from those local areas. So I think it's just incumbent on partners to just review that role that they all have, that healthy challenge is there in relation to decisions to notify, and of course panel are there to support that in relation. So what we understand are sometimes are very clear decisions, sometimes there is clearly a level of complexity in relation to whether notification and therefore what the review process takes place from there.
Yeah, good, thank you. And I think that picks up on question 12 as well, around it'd be helpful to have a contact line, and Amina has responded to that with the mailbox, and also the process around where possible the secretary will allocate your query to a panel regional lead who will then seek to help via email or if needed a meeting or a call. So there is that support out there, as Ian and David have both reiterated. Thank you.
Steve, while Kelly's thinking
Yes.
about that, maybe there's a point I could make as well, because I'm conscious, colleagues, that we're asking you to do things on this call. We're asking you to make serious incident notifications when they need to be made, but also to say, there is, I think, more that the panel can do as well. One of the things that we're focusing a lot on at the moment is we see so much learning being produced by local safeguarding partnerships as a result of rapid reviews and local child safeguarding practice reviews, and we're thinking really actively about how we can help to identify the very best learning and help to share that learning ourselves. So when we have our new learning resource hub in the new year, as well as generating content for that website, that learning hub ourselves, we will also be looking to create a platform for the very best learning that we've seen from rapid reviews and LCSPRs that have been submitted to us as well. So, you know, we're all in this together, colleagues. We need to get the notifications in, we need to get the learning out, and we're all part of that system.
There's quite a debate which is from number 18 and 24. 18, it would be so helpful if there could be a more realistic approach to the rapid review timescales instead of submission by 15 days. Reviews held in 15 days with 5 days of report submission would improve quality. You mentioned this earlier, David. Is that something that you're looking at?
Again, I think Ian talked about the balance between getting the learning understood and shared as soon as possible, and also producing a good quality report. If you're going to really struggle to meet the 15-day timescale, and there's a really good reason for that, then get in contact with us and talk to us about it. So, and you know, we are always willing to talk. Equally, we're responsible for a system that is seeking to learn rapidly from these incidents and to sort of get that learning shared really quickly. So we're balancing that. But if in doubt, talk to us.
Yeah, thank you. Sally, do you want to comment on that?
Yes, we did have some protracted discussions about this when we revised the guidance. It is actually a requirement and working together to undertake it within 15 days. So we didn't really have the latitude to be able to change that. What we do know from our annual review data is, I can't remember whether it's about 95% of reviews do come in within that 15-day timeframe, and the quality of those is really good. And I think, as David has said, if there are key reasons, really good reasons why you're not going to hit that 15-day timeline, then Safeguarding Partnerships do email the mailbox and we can have a sensible conversation about it. And many Safeguarding Partnerships do that.
Good, thank you very much. So a chance for a couple more questions, and I am monitoring to see if anybody wants to ask a verbal question, but can we just pick up on number 21, which is reiterated by number 46 as well. So 21 talks about could you publish anonymized exemplars of good and poor RRs? Circumstances where you disagree with the local decisions or do not do a CSPR. Now, Amina has helpfully put the link to the website where you do publish rapid review examples, but maybe a little bit more about a poor example as well. Of course, it'll be anonymized, and then that perhaps that conflict where you disagree with the decisions that have been made locally.
That may be a rich topic for a future webinar, Steve, to actually talk about you know, some of those broad areas that we see, because we consider so many of these rapid reviews, about why we may not agree with the decision a Safeguarding Partnership has come to. What we always do, though, is when we have considered a rapid review, we will always then write to the Safeguarding Partnership to explain why we may disagree with the decision they've reached and give reasons. And I'm really keen that you know, we in the letters we write, that we're giving, you know, as much context to the discussion we've had and as much useful information as we can, because you know, often again, this is a conversation that we need to have with the Safeguarding Partnership, and maybe there is more information that can then subsequently be shared with panel, perhaps that we were not aware of, that we just need to understand ourselves. But it's why dialogue is so important.
Yeah, Yeah, thank you. And in terms of a call for dialogue, 46 says, I think a more detailed feedback on our rapid reviews would be supportive, including your view on whether the threshold guidance has been interpreted appropriately in your view. So yeah, that, as you say, that might be a good topic for a future webinar. Just a chance for a very quick response. There was a question 35. Perhaps to Ian, what is your view on conducting rapid reviews where children might now be over 18? And should that review take place? And what considerations should be made here? Equally, there are delays for police investigations, and how should we work around these with respect to rapid reviews submitted within 15 days?
Yeah, some really good points, and thanks for raising them. I think we put some additional information in the guidance in relation to considerations of people, young people that were abused in childhood but were now 18. And of course, what we shouldn't have is a system where one day a person is under the age, the next day they are 1 day older, and we preclude the ability of what the system is all about in terms of identifying, learning, and I suppose the considerations that we ask partners to determine are when that primary harm occurred, to what extent did that take place while that young person was a child, around it, and to what extent time has elapsed that learning may have already taken place. And again, we know partners seek specific guidance, but this is one area that again needs to be considered on a case by case basis, and of course also in terms of what may be parallel proceedings, or indeed other proceedings that might take precedent, such as adult reviews or domestic homicide reviews, to make sure there's a very clear join up between the reviews and a determination as to which review takes precedence. And where we can do it one way, of course, we should be able to do that. In relation to the police investigation, hopefully I covered that in an earlier point, but I suppose just to reiterate, the importance of not interfering with justice is absolute, and making public or interfering with witnesses that may well be part of the process. But we have found with some really good dialogue with partners, considering parameters at an early stage, that often allows a review to either to be part complete or indeed to be fully complete, to allow that learning to get back into the system. And just determining publication issues, obviously prior to any court proceedings taking place, are often the ones that need to be put on hold. But we have found, and that again I think is open to important challenge amongst partnerships, because there's often been this, the review can't proceed because there is a police investigation. We just ask that dialogue to take place between the parties, and to see how we can rather than why we can't is often a good starting point.
Yeah. Thank you, Ian. And 48 covers this as well. What if evidence does come to light on abuse and neglect until after the child death review? That can be months down the line. So I think again you covered that. We're rapidly running out of time, and I want to give David a couple of minutes just to kind of close us out. But 47, just as a reminder, and I think please go back and watch some previous webinars on this and the panel's plans on how to disseminate the learning that they are collecting. 47 says the challenge is not just about identifying the learning. The major issue lies in getting the learning out and embedded. The system is flooded with learning, and frontline practitioners do not have the protected time to attend or engage with learning materials. How do we tackle this as a system when a lot of organizations are focusing on meetings and stats and mandatory learning requirements only? So I know you have a lot of plans that you're probably not going to be able to cover now, David, but previous webinars have covered that. And I'm sort of handing that back to you with 2 minutes to close us out. Sorry.
Oh, okay. Thanks very much, Steve. So just to respond immediately to that point about the system being flooded with learning. Yes, I know. I agree. And that's why we're thinking really carefully about how to get our own online learning hub right, and why we're also developing it directly with frontline practitioners as well, so that we're as informed as possible about how to make a positive difference. Just really to conclude, colleagues, I just wanted to thank you for joining us at this webinar today. I really appreciate your time. I'm really grateful for my colleagues' contributions from Sally and Ian and Steve for keeping us in order. But just to really emphasise that we're all working to keep children safe. We're all working to learn from these really serious incidents. Please view the guidance as a live document. If there's something in it that you don't think is right or that's unclear or needs to be covered in more detail or needs further explanation, let us know, and we can just keep that in mind when we're next updating the guidance. And also that key message that you can always reach out and ask the panel, engage with us if you've got questions about when to notify or questions about a rapid review or an LCSPR. We are very keen to engage with everyone and to do whatever we can to help. So thank you all very much.
Great. Thank you, David. Thank you, Sally. And thank you, Ian. Thanks for joining us today. Look out for the answers to the questions that you submitted into the forum. We'll produce a report for that, be published on the National Panel website through the DFE. And we have upcoming webinars as well, so watch out for notifications on those. Thanks for sticking with us, and have an enjoyable evening. Thanks a lot, everyone. Goodbye.
Thanks, everyone. Thank you. Bye-bye.
Thank you.
Thank you.